Hello, my name is Haitham Amin. I go by Sam. I'm the principal attorney here at Amin Law in San Francisco, California. Today, we will be discussing California Penal Code Section 69, commonly known as resisting an executive officer. I'll also discuss what the DA will have to prove in order to secure a conviction, possible defenses, and punishment in the event of a conviction. Prosecutors will have to prove the following in order to secure a conviction. Number one, defendant tried to prevent an executive officer from performing his or her duties, or number two, defendant resisted an executive officer in the performance of his or her duties. Under a prevention offense, the prosecutors must also prove the following two additional elements in order to secure a conviction against the defendant. Number one, the prosecutors must prove that the defendant willfully and unlawfully used violence or a threat of violence to try to prevent an officer from performing a lawful duty. Number two, the prosecutors must show that the defendant acted so intentionally. Under the resistance offense, the prosecutors must prove the following additional three things to secure a conviction. Number one, the prosecutors must show that defendant unlawfully used force or violence to resist an executive officer. And number two, when a defendant acted, the officer was performing what's known as the lawful duty. And finally, number three, when a defendant acted, he or she knew the officer was in fact performing a lawful duty. Three main defenses you can argue, or rather produce in court to prove your innocence. Number one, the officer's conduct was unlawful. An officer must be performing some lawful duty in order for a defendant to be found guilty. The defendant must show, while she or he may have interfered with an officer, that specific officer was acting unlawfully. Also, an officer is not lawfully performing his or her duties if he or she is unlawfully arresting or detaining someone or using unreasonable or what's known as excessive force in his or her duties. This defense will require the defendant to file what is known as a petition motion. It's a pretrial motion. This is a request for information contained in a law enforcement officer's personnel file. The motion should be filed when and if the defense believes their client has been a victim of police misconduct. Number two, self-defense. If a defendant resisted an executive officer who was using, say, excessive force against him or her, the accused or the defendant is entitled to exercise his or her right to defend him or herself in accordance with the law. Now remember, the force used has to be reasonable under the circumstances. Finally, number three, no executive officer. Remember, the code applies only to executive officers. This means it is a valid defense for an accused to show that the alleged victim does not meet the definition of an executive officer. What's an executive officer, you ask? Well, executive officer is defined as a government official who may use his or her own discretion in performing his or her duties. For example, police officers, sheriffs, judges, prosecutors, defense attorneys, and elected officials. Punishment. Violation of California Penal Code 69 is a wobbler offense, meaning it can be charged as either a misdemeanor or a felony. If charged as a misdemeanor, the offense is punishable by probation, court probation generally, or summary probation, up to 1 year in county jail, and or a max fine of $10,000. If the offense is charged as a felony, the punishment is as follows. Generally, a felony probation or formal probation, up to 3 years in county jail, and or a fine of up to $10,000. As always, thank you for watching. I have a team of professionals who are ready to help. All you have to do is pick up the phone and give us a call. If you found this video educational, I'd greatly appreciate it if you can share it. Of course, don't forget to like, comment, and subscribe. Bye-bye.